Matt Woods here with First Alert 4. Thanks for tuning in. If you haven't listened to episode 1, go do that first and then come back. Also, a few disclaimers before you listen. This series discusses sexual assault and contains language some may find offensive. Listener discretion is advised. It was around 5 a.m. on May 21st, 1988, when a 21-year-old woman was walking home from her boyfriend's house. They had been in an argument while they were outside his apartment in his car. He went inside, and she did not. She decided to walk to her grandma's house, where she lived. It was about 10 blocks away. She got out of the car, parked near McCree Avenue in St. Louis's Botanical Heights neighborhood. The woman was 7 months pregnant with a baby boy. She had on a Pea Patch brand tunic dress and pink slippers. She was carrying a small tan wallet. The woman turned off McCree onto Spring Avenue going north. There's a park just to the left and an apartment building to the right. A 2-door, older model Chevy, dark blue or green in color, drove by with 3 men inside. One of them asked the woman if she needed a ride. She replied no, and they kept driving. Then the car made a U-turn, and the front seat passenger jumped out and approached the woman. He grabbed her by the hair, struck her in the face, and dragged her into a nearby alley. The driver pulled the car partially into the alley. Him and the other man got out and held the woman down by her hands. The first attacker then raped and sodomized the woman. After a few minutes of sexually assaulting her, the 3 men drove away in the alley. The woman was left there, her dress torn and her personal items laying around. Former St. Louis police officers Ruin Hammond and James Long got a radio call to respond to the scene. Here's Hammond.
She was upset, said that 2 persons held her down while another person raped her.
After the crime, 2 men driving by saw the woman on the sidewalk crying. She told them she had been raped and needed help. They asked her if she knew who attacked her, but she was inconsolable. Officers Hammond and Long responded to the hospital to interview the victim. There she gave descriptions of the 3 men who attacked her. She said they were around 24 to 26 years old. She said the man who raped her was 5'11 to 6'2" tall, slim build, light brown skin, brown eyes, and black hair. He had on a red baseball hat and blue jeans. At the hospital, the victim didn't tell the hospital staff or the police she knew who attacked her, and she didn't say any names. An all-points bulletin was put out with the suspect descriptions, but there were no developments that day. When Officer Long went back on shift that night around 11, he had a phone call. It was the victim. The following is the police narrative of what happened next. The victim called Long because she wanted her wallet back. It had some money and papers in it that she needed. Long and her talked about how they could get the items back to her. After that, Long asked her if she remembered anything else from the crime. According to the police report, that's when she said, for the first time, that she knew of the man who raped her, that she had seen him in the neighborhood before, and she remembered his name. The officers knew someone with that name who lived in the neighborhood, so they put together a photo spread with 5 different mugshots and went to the victim's home to show her. She picked out the second photo, giving the officers probable cause to arrest that man for rape and sodomy. Within 24 hours, Frederico Lowe-Bey was under arrest. From First Alert 4, I'm Matt Woods, and this is Burden of Proof. One man's fight to show he's innocent. This is a true story about how difficult it is to prove actual innocence after a jury has declared you guilty. The next night, Frederico and his then-girlfriend, Shervon Johnson, were in the apartment when there was a knock on the door.
Fred was getting ready to put my daughter down, and we had our night clothes on, and we getting ready for bed. And so just boom, 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 boom. And I'm like, who the hell is that knocking on that door like that, And they just boom, 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 like they was going to come through. And I stood at the top stairs, I say, I'm coming, give me time to come down the steps. I say, who is it? That's the police. Open the damn door. Boom, boom, boom. So no sooner as I go down the steps and open the door, they push me aside. He pushed the door one way and pushed me aside.
Frederico said that's a night he'll never forget.
And when she opened the door, they just rushed in. Rushed right on up the steps. And came and had the guns drawn and told me to lay across the bed. At that time, I had my daughter in my hand. And he told me to put the baby down. And I set my daughter down on the bed, and he told me to lay across the bed, put my hands behind my back. I laid across the bed, put my hands behind my back, and he put the handcuffs on me and brought me down the steps. When he brought me down the steps, Siobhan kept asking him, say, man, what are you locking him up for? What did he do?
And he said that he raped somebody. I said, man, he ain't raped nobody. Y'all know he ain't raped nobody. And Fred looked there and said, baby, you know I'm not good for that.
The nature of the crime was much different than what Frederico had been charged with before. He got caught selling drugs and stealing cars, but never something like rape. The central issue in the case against Frederico Lowe-Bey was identification. There was no physical evidence linking him to the crime. They couldn't test the DNA and get a unique profile in 1988. No one else was ever charged in this crime, so there wasn't another suspect that could connect him to the scene. And police never identified the suspect vehicle. The question for the jury would be whether or not the victim's identification was credible. This is where I'm going to get into the weeds about how, when, and what the victim's identification of the rapist was. Because the identification is ultimately what put Frederico behind bars. Without it, there was no case. There are two different characteristics of the rapist in this case to focus on: a gold tooth and freckles. Some of the others, like skin tone and height, are definitely important, but the gold tooth and freckles stand out, and for different reasons that I'll get into. Those identifiers are somewhat more unique than, say, light skin or black hair. So as we go along, remember gold tooth and freckles as focal points in this crime that relied completely on identification. If you just read through the trial transcripts, it can be easy to look over. Some of it appears like subtle differences that appear in any case where identification is a factor. But if you break it down by what's in the police report versus what was said in depositions to what was said at trial, it starts to look a lot more gray. So here's what I'm talking about. I'm going to break this down person by person because otherwise it's nearly impossible to keep track of. Bear with me because it's not linear. It's more like a maze. Let's start with Officer Hammond because he was the first to take the stand at a pretrial hearing. He's also the one who did most of the interviewing of the victim at the hospital. He said the victim's description was a light-skinned man with a gold tooth. He said that in a deposition at the pretrial hearing and at trial. And the victim did so as well. But there's a discrepancy about the gold tooth. It's absent in the narrative portion of the police report. That's the part where they describe the incident in detail. It goes beyond just the date, time, and location of the incident. It's paragraphs of what the officers saw on the scene, what witnesses said, descriptions of suspects, and so on. That part gives you a lot more information on what happened. So the narrative portion of this police report listed the descriptions of the three suspects. It described suspect number 1, the rapist, as a light-skinned man, 24 to 26 years old, 5'11 to 6'2", brown eyes, black hair, wearing blue jeans and a red baseball hat. But it doesn't say gold tooth there, and not for the other two suspects either. And it was an important question to answer because Frederico Lowe-Bey does have a gold tooth. Here's Jim McCloskey with Centurion Ministries, who took on Frederico's case.
Frederico had does have a prominent gold tooth in the upper front of his mouth, and that was never part of the description given immediately after she was raped.
On the stand, the defense asked Hammond why the gold tooth was not included in the narrative portion of the police report. His response was that the gold tooth was listed on the suspect page of the report. The suspect page is where it includes a name of the suspect, if you have one, and their physical characteristics. On that page, but not the narrative pages, it lists under Frederico Lowe-Bey, teeth gold. But he didn't explain why he was on one part of the report and not the other. The location of Frederico's gold tooth in the upper front of his mouth was not listed anywhere in the report, even on the suspect page. When I talked to Hammond, he said, for one, that's just way too long ago to remember.
Man, I don't know. 37 years ago. I really don't know. But I'm sure everything was brought up during the trial. So his lawyer had the full police report and some. So I don't, if there was a discrepancy, it would have been brought up during the trial.
Another layer to the gold tooth description is that Hammond didn't prepare the police report until after he and Long obtained the identification of Frederico. So the officers interview the victim at the hospital the morning of the crime, around 6:30. Hammond puts the suspect descriptions into a computer at 7:45 and then goes off shift. What Frederico's lawyers claim in legal filings post-conviction is that when Hammond entered those descriptions, the gold tooth was not included. That was before the victim had identified any person by name. The officers had the identification of Frederico by first name 14 hours later. It was around 11 p.m. that night when they went back on shift. 4 hours or so after that, around 3 a.m., is when Hammond prepared the police report. That police report has gold tooth on the suspect page with Frederico's name, but not in the narrative paragraphs that describe the incident. But Hammond maintained under oath that the victim included a gold tooth in her first description at the hospital the same morning of the rape. And in his interview with me, he said not preparing the police report until the next shift was actually no big deal. Why wouldn't you prepare the police report when you got back that morning right after interviewing the victim at the hospital?
Because we have nothing else. We got notes. We had nothing else to put in the report.
So you wouldn't. So that would be normal for you to not prepare a police report?
Yeah, wouldn't be a big deal.
In the trial, the question of why gold tooth was on the suspect page of the police report but not in the narrative portion was never really answered. Hammond testified that it was included in the report. But in the presence of the jury, the defense never asked him to explain why he was absent from the narrative descriptions. Hammond, along with his partner James Long, testified they checked the report for accuracy before they prepared it. Both officers and the victim testified at trial that the description included a gold tooth. The second main characteristic of the rapist is one that Frederico Lowe-Bey does not have: freckles. Officer Long was testifying about a phone call with the victim when that description appeared, seemingly for the first time. According to him, the victim had just told him over the phone that she knew the suspect from seeing him in the neighborhood, and she thought his nickname was Fred Rico, as in like two separate names. Then Long said he asked what the suspect looked like.
At the suppression hearing before the trial, which was right before the trial, Long testified that she told him that her offender, her rapist, had freckles.
Someone brought up that he had freckles. I'll never forget that. And I'm like, Fred ain't got no freckles.
It was at the pre-trial hearing, a day before trial and out of the presence of the jury, that Long gave that testimony. Up to that point in the case, freckles did not appear in the description of the rapist. It's not anywhere in the police report. The victim and officers didn't say it in depositions. But light-complected with freckles was Long's testimony of the rapist's description right before the trial. Somehow, Frederico's attorney Andrew Hernandez glosses over the freckles description with Officer Long on the stand. He doesn't ask him any more questions about it, not before or during the trial.
Lowe-Bey does not have freckles. That's such a distinctive mark on a black man. It's incredible, and nobody says a word about it. Nothing.
That's Paul Castellero, also with Centurion and part of Frederico's legal team. He said the freckles description is part of what makes this case so frustrating.
And it never, ever comes out. It's unbelievable. It's mind-boggling, actually, when you think about it. I mean, there's no explanation for it other than incompetence.
It's unclear why freckles was absent from the police report if the victim had told that to Officer Long in the phone call. That phone call was about 4 hours before the police report was prepared. But the report was prepared by Hammond, who wasn't actually listening on the phone call. Long got the phone call with two pieces of information: a man in the neighborhood named Frederico, and who was light-complected with freckles. Long and Hammond knew of a guy named Frederico who they had arrested before, and so they put him in a 5-person photo spread to show the victim. After that, Hammond's report included Frederico Lowe-Bey as the suspect, but there was no mention of freckles anywhere as part of the victim's description of the rapist. So the freckles part of the description is washed under the bridge. And since Long only testified about the freckles in the pretrial hearing, it was out of the presence of the jury.
I don't have no freckles on my face. So that ain't Frederico. You only naming Frederico by name. You ain't not naming Frederico by identification.
I brought this up to Hammond.
Frederico Lowe-Bey does not have freckles.
He's subtly shaking his head side to side as I ask him about it.
Does that hold any weight to you?
Yeah, no, everything is presented to a jury. A jury of 12 people got to hear all the evidence, not just us. Got to hear the victim's testimony, got to hear all the doctor's testimony, got to hear everything. So the jury believed that Frederico Lowe-Bey did the rape.
His defense attorney never brought it out at trial from the pretrial hearing that the jury wasn't present for, and then it never comes out at trial, this discrepancy. But this man has his face is clear. You can't say that he has freckles.
His attorney should have brought it up. I don't.
But the photo spread that was taken to the victim.
I understand that.
None of the 5 people in the photo spread had freckles.
And the victim might have thought of something later on. I don't know. But she had to testify in the trial that she was convinced that Frederico Lowe-Bey raped her.
So Hammond is saying the defense had a chance to bring this up at trial. And after the victim gave what she thought was a nickname, picked him in a photo spread, and then in an in-person lineup, that was enough for them to apply for warrants. And beyond that, the legal process played out. The St. Louis Circuit Attorney's Office prosecuted Frederico, and a jury decided he was guilty. He also said he couldn't recall the victim ever saying the rapist had freckles, but that whatever he put in the report would have been what he remembered the victim telling him. Also, I did ask Hammond directly.
Do you remember Frederico Lowe-Bey having freckles?
No, I don't.
Long's testimony was not the last time freckles would come up in the identification of Frederico Lowe-Bey. It wouldn't show up again until 19 years after the trial, and it adds more confusion to the record. After the DNA results came back in 2005 and they were negative for Frederico, the judge overseeing the proceedings forced the state to produce the victim so she and the attorneys could ask her questions. They were trying to figure out whose DNA was on the rape kit, but were coming up short. And it was at a hearing on April 20th, 2007, when this detail of the freckles would be entered into the record again. The judge cleared the courtroom except for the attorneys and Jim McCloskey. The victim was brought in from the witness room and sworn in. According to the transcript of that hearing, the judge began asking the victim questions about identifying her attackers. "I recognized one," the victim said. "And who was that?" the judge asked. She replied, "That was Frederico Lowe." A few moments later, the judge asks her if she knew what he looked like, and she said, quote, "Yeah, he was light-skinned and with freckles. I hated that. It was scary to me," end quote. Here's McCloskey, who heard it firsthand.
That was the most significant physical aspect to a rapist that she clearly remembers. And Frederico doesn't have a freckle on his face.
Later in that same hearing, Frederico's post-conviction attorney, Scott Thompson, asked her this question. "And at the hospital, did you tell police that it was a black male who raped you?" Her response, quote, "Yes, light-skinned with freckles, right," end quote. So to recap up to this point on the freckles, it's not in the police report. Long testified right before the trial that it was included in the victim's description of the rapist. Frederico's attorney never cross-examined him about it while he was under oath. And then 19 years later in a hearing, what the victim remembered of the rapist was a light-skinned man with scary freckles. There's also another person who claims she heard the victim say the rapist had freckles. That person was a close friend of the victim. This came to light as part of an investigation Centurion conducted starting in the late 2000s. They spoke to several people who knew the victim, one of them being this close friend. One of Frederico's attorneys interviewed her at her home in July 2011. According to an affidavit, the friend recalled a conversation with the victim from a few years prior. It was right around the time when the DNA hearings were held and the victim testified. The affidavit says the victim insisted to the friend that the rapist had a face full of freckles. When the friend mentioned that Frederico does not have freckles, her response was that he must have painted freckles on his face because she was absolutely certain the rapist was freckled. I spoke to this friend over the phone for this story, and she confirmed the victim told her the rapist was a man with freckles. She initially agreed to do an interview with me, but she had mentioned that she was recently displaced by a tornado that swept through St. Louis a few months prior. She didn't answer my follow-up calls or messages. The other important factor of the identification is when and how the victim told police who she thought had raped her. She didn't give a name at the scene or at the hospital, according to the officers. In the phone call about the wallet, after being asked by Long, then she made the identification with what she thought was a nickname. Drilling this part down required looking at several different instances the victim was under oath. During the trial, the prosecutor laid the foundation for the phone call, which is when police say she identified Frederico. The prosecutor, Mary Ann Medler, asked the victim if she told Long anything else when she talked to him on the phone about who raped her. To that question, she replied, no. That answer didn't coincide with the state's narrative, so the prosecutor followed up by asking if she gave them a name in the phone call. To that, the victim said she didn't remember. Then the prosecutor broadens the question entirely. What did you ever tell the police about the name of the person who raped you? That question she answered by saying she remembered seeing a person in the neighborhood by the name of Frederico. There are two other answers the victim gives to the same question of when she gave the name Frederico. Let's back up to pre-trial testimony. I would describe it from the transcripts, but Frederico brought this up in an interview, and he cites it almost verbatim.
My lawyer asked, well, didn't you identify Frederico as the person who raped you? She said, I didn't say of him. I said of the person who raped me. He said, but you did say Frederico was the person that raped you, did you not? She said, yes, I did, after I saw the picture.
The photo spread was directly after the phone call. The officers took the photo spread to the victim with Frederico included because they claimed she had just given the name to Long in the phone call. So the officer said it went like this: descriptions only at the hospital, then the first name in a phone call, then the identification in a photo spread. But the victim said something different every time she was under oath. She said in a deposition that she gave the name at the hospital. Right before the trial, she said she gave the name after seeing the picture in the photo spread. And during the trial, she said she couldn't remember if she gave the name in the phone call. Hammond and Long both described the identification in this case as being cut and dry on their part. She gave Long the name in a phone call, they took over the photo spread, and she identified Frederico almost immediately. According to Hammond, she was certain that it was him.
We brought over the picture spread. She identified Frederico Lowe-Bey, and at that time we put a warrant out for him.
Did she identify him immediately? Do you remember?
Is that pretty much so.
She said, this is the man who raped and sodomized me, and she was, how sure would you say you think she was?
100%.
The victim maintained Frederico Lowe-Bey was the person who raped her at trial. During the state's case, she identified him in the courtroom as the perpetrator. And that was what the state hinged on to meet their burden of proof. The state's theory that Frederico Lowe-Bey raped and sodomized a woman in a South City alley places him near the corner of Spring and Folsom at 5 a.m. on May 21, 1988. The defense's counter to that was that he couldn't be in that alley because he was at home sleeping during that time. Frederico did not testify on the advice of his attorney, but his alibi witness was Shervon Johnson. She testified that she and Frederico were home when the rape happened. They lived on Shaw Boulevard, a block south of Highway 44, which divides the neighborhoods to the north and south. Just north of the highway is the intersection of Spring and Folsom, where the rape happened, so it's only a few minutes away. But Johnson testified that for the simple fact that Frederico was at home, in their bed, at 5 a.m., he couldn't have been the rapist. She's still adamant to this day that he couldn't have done it.
If I feel Fred had done it in any type of way, I wouldn't have stood by him. You know what I'm saying? I would have told the truth. Where he wasn't with me and so, I don't know where he was, but he was with me, him, and my daughter.
So if he had left the house, you would have testified
known. Yeah, I would have known. If he had left the house.
Johnson testified that the same night of the rape, she and Frederico were at a friend's house until about 10:30. Then they went home and put her daughter down and stayed up after that. She said they went to bed around 2:30, maybe 3, and it was a few hours later that the rape happened. But Johnson said she doesn't think he left the house that morning.
I don't care what questions you in, which way you rephrase it and this, that, and the other. It's the truth. And ain't nothing going to change in what I'm saying.
And when you came off the stand, did you feel like the jury believed what you were saying?
Yes. Because, it was the truth, and how could you not believe what I'm saying? I'm not sitting up there, none of this. I'm sitting up there looking dead faced eye to eye with him when he's asking me these questions, It wasn't no nervousness, none of that.
She also said she thinks she would have heard the rape allegation from someone else on the street if it was Frederico. But she claimed to me that she never did.
Some kind of way, if he had raped that lady, it would have gotten back to me. Somebody's going to let me know that he did that, But everybody was shocked. Everybody was shocked because they know Fred didn't have to rape anyone.
The prosecution tried to undermine Johnson's credibility. They claimed that Johnson was testifying for Frederico because she was scared of him. Their offer of proof was that Frederico slapped her after a verbal argument one time at a friend's house. Someone else who was there called the police. She testified during the rape trial that they made up after the argument and the charges were never pursued. 37 years later, Johnson did not describe Frederico as an abusive person. Quite the opposite, actually.
I believe when you testified, the prosecution tried to make it seem like you were afraid of Frederico, and that's why you were testifying on his behalf.
No, I was testifying on his behalf because it was the truth. I was there, afraid. I'm not going to be living with anybody I'm afraid of. Sleeping in the same bed with someone I'm afraid of. Have my child around someone I'm afraid of. Not afraid of him. I wasn't afraid of him. I'm telling the truth. Simple as that. And they tried to mix me up, but they couldn't. Because the truth, if you're telling the truth, you can't do nothing but tell the truth. You can't touch that. And once I came off that stand, and they say I was a good witness, because they couldn't twist. They tried to twist me, and, no.
So the jury had a decision to make after hearing the victim's testimony compared to Johnson's. If the jury believed Johnson saying Frederico was at home with her when the crime happened, they would have to vote not guilty. It would have been physically impossible for him to have done it. But you also have to consider that during the state's case, the victim identified Frederico in the courtroom as the person who raped and sodomized her. It's a powerful moment in a courtroom when they ask, is the person who committed this crime in the courtroom today? And they say yes and point to the defendant. It's damning and convincing. The defense tried to attack the credibility of Officers Hammond and Long. Public Defender Andrew Hernandez tried to make it seem like they had it out for Frederico, that they wanted him locked up and were going to get him one way or another. They had arrested him on 3 occasions. The first was the marijuana possession charge in July of 1987. Frederico was acquitted of that charge in April the next year. The second arrest was later that month, and that's the arrest Frederico filed an internal affairs complaint over. He claimed they roughed him up on the way to the police station. And the third arrest was for rape and sodomy, which landed him in prison for 85 years. The defense's theory was that Hammond and Long had a vendetta against Frederico, and that was motivation for them to investigate him and apply for charges. Frederico still claims that to this day. He refers to the so-called establishment. To him, it's not just the police, it's also the prosecutors, the judges. He portrays what he alleges is a wrongful conviction as purposeful, not a mistake. Hammond and Long both adamantly denied there was ever a vendetta. They responded to it like it was an outlandish allegation. They claimed Frederico was just another guy in the neighborhood that they had arrested. They both testified at trial that they did not hold animosity towards Frederico. The defense wanted to include the prior history between Hammond and Long and Frederico in an effort to prove a conspiracy against him. The prosecution didn't want any of it to be allowed at trial. Prosecutor Mary Ann Medler made a motion before the officers testified to ask the court to disallow the prior history between Frederico and the officers. She asked for there to be no mention of any complaint filed by Frederico or any other defendant to Internal Affairs, that there be no mention of any lawsuit filed by Frederico or any other person against the officers, and that there be no mention of any other trials in which Frederico was arrested by Hammond and Long and later acquitted. In addition to the Internal Affairs complaint, Frederico filed a civil rights lawsuit against Hammond and Long that was pending during the trial. It eventually ended in favor of the officers. The judge said the prior arrest was unimportant to the case at hand. He thought it might lead to trying a case within a case. So for the time being, he didn't want the defense to get into prior incidents between Frederico and the officers. The Internal Affairs complaint and civil rights lawsuit that Frederico filed against the officers did eventually come into the trial. The defense was allowed to ask the officers if Frederico filed a complaint and lawsuit against them, but they weren't allowed to ask about the accusations within them. The Internal Affairs complaint was ruled not sustained by the department's Internal Review Board. Frederico said they took pictures of him, and he also had medical files from a hospital visit. But the board ruled that there wasn't enough evidence. They didn't hold a hearing. Later on in the trial, the judge decided to allow the prosecution to tell the jury that the Internal Affairs complaint was ruled not sustained. His reasoning was that he didn't want the jury to speculate one way or the other about the outcome. Frederico's public defender then asked the judge to also allow him to mention the outcome of the drug possession trial. But the judge said that was like comparing apples to oranges. His argument was that the jury wouldn't hear about his prior convictions, so it wouldn't make sense for them to hear about a prior acquittal, even if the acquittal involved the same officers as the rape case. So the jury wouldn't hear much of the backstory. The only thing they heard about the Internal Affairs complaint is that it ended in favor of the officers. And there's a question about the officers not raised at trial that Frederico's legal team makes a point of in post-conviction filings. In 1988, Hammond and Long were patrolmen. They were not sex crimes detectives, but they wrote the report and obtained the identification from the victim in this rape case. They also conducted the in-person lineup. In a legal filing in 2014, Frederico's attorneys claim the officers violated department policy by not transferring the case to the rape division. Hammond told me that after responding to the rape, they called for the sex crimes unit at the scene, but that they passed it down to them. He said maybe they just didn't want to do it.
We called for sex crimes that morning, and they said handle it district level.
So they told you
handle it district level.
Handle it district level. Was that standard back then?
Sometimes they get off the same times we do. Maybe they didn't want to stay over at that time.
As for the policy question that Frederico's lawyers bring up, Hammond said it was whatever the sex crimes unit said. If they said to handle it at district level, that's what you did. Frederico's attorneys go even further than saying the sex crimes unit didn't investigate the rape. They claim in the same filing that no detective, not just a sex crimes detective, but any detective period, investigated the incident. At trial, Hammond testified that sex crimes did in fact conduct an investigation that followed his and Long's work. But if that's true, it didn't turn up much. The other two attackers were never identified. Neither was the suspect vehicle. There was another element to the case against Frederico Lowe-Bey that bolstered the state's allegations against him, and it was included in the trial for rape and sodomy. Frederico got 15 years for this charge, and he's already served 37 years in prison. So for that reason, I haven't focused on this aspect until this point. But it was part of the trial, and it likely helped him get convicted on the other two charges. So on June 1st, 1988, 10 days after the rape, the victim got a phone call at her grandmother's house. When she answered, it was a woman on the other line. And then a third party was transferred in. And according to the victim, that person threatened to have her killed if she didn't drop the charges. The police were called and a report was taken. And Frederico was then charged with tampering with a witness. This phone call added credibility to the rape and sodomy Frederico was already accused of.
The victim said, I called her and threatened her. I didn't call her. The telephone company say where we used the telephone at down in the city jail, it couldn't have never came from that jail and going to her. I had witnesses that we was locked down at that time on a Wednesday. I could never call her and threaten her. I never called her. They gave me that sentence anyway. Why?
She said she recognized your voice.
Because she recognized me in the alley, right? That's what she said. I remember his voice from the alley.
He claims at the time of the alleged phone call, the floor was on lockdown. Everyone was in their individual cells without access to the phones. One of the defense's witnesses was a correctional officer named Darrell Lewis Pitchford. He testified that another correctional officer brought Frederico out of the lockdown area to talk to him after law enforcement got wind of the threatening call. But Hernandez, Frederico's attorney, didn't ask him if Frederico being in the lockdown area would mean he didn't have access to the phones. Hernandez also said during the trial that he was going to subpoena records from the phone company, but there's no indication that he did. The prosecution had 2 correctional officers and a police officer testify about the phone call. The call was able to be pinned down right around 11:40 a.m. The cop testified that he got a radio assignment at 11:55 a.m. to respond to the victim's home. But the time he got there and spoke to her and then called the jail, it was after 12. At that time, a jail supervisor had a correctional officer check if Frederico was on the phone. That correctional officer testified at the trial that he did see Frederico using the phone at that time. By that point, it would have been at least 20 minutes after the threatening call was made. Still, the correctional officer testified that he saw Frederico on the phone between 11:20 and 11:40 that day. Also, the prosecution wasn't able to prove the phone call actually came from the jail. The phone company couldn't say the exact number the call came from. They were able to say that the phone call came from the downtown St. Louis area. The jail is in downtown St. Louis, but the phone call that was traced was the first caller, not the one that was transferred in. The phone company had a prefix for the phone number of the first caller, but that was not the same prefix as the jail detainee phones. In prosecutor Marianne Medler's closing arguments, she told the jury that she needed one witness to prove the state's case. The victim is this case, she said. If they believed her beyond a reasonable doubt, then her testimony alone was enough to convict Frederico Lowe-Bey. Frederico's attorney, Andrew Hernandez, tried to paint a picture of bias from Officers Hammond and Long. He pointed to the internal affairs complaint, the pending civil rights lawsuit, and an assault they arrested Frederico for in which he was never charged. He also cast doubt on the accuracy of the victim's testimony. The jury deliberated for around 3 hours after the trial concluded. Late that night, they returned their verdict. Guilty on all charges. Shervon Johnson was in the courtroom when Judge Richard Meehan handed down sentencing.
When they started calling off all those years, I just got up and walked out because I knew, I wasn't going to see him anymore. Not a free man, and I went to the bar and started drinking, because I didn't know what else to do. They finally got him. They said they were.
Was there a moment that you accepted the fate that he was given, that he was going to die in prison?
That day. When I heard that 85, and I walked out the car, I said, I'll never see Fred again. I just knew it.
35 years for rape, 35 years for sodomy, and 15 years for tampering with a witness. It was exactly what the prosecution recommended for sentencing. The charges were to run consecutive, meaning one after the other. 85 years total. It was the maximum possible sentence. And he has to serve 80% of each sentence to be eligible for parole, effectively denying him that as well. The sentence gave a sense of finality to Frederico's fate. What followed, though, is a decades-long pursuit to prove he was actually innocent. Before Judge Meehan's sentencing, Frederico told the judge he wasn't the right man for the crime. He went on for a long time. It's about 2,000 words in all. He said he would never stoop that low to rape somebody, something he's often repeated to me. He also said a black person doesn't stand a chance of winning anything with public defenders representing them. Since that day that he was sentenced to life in prison, he's been trying to convince a court and the public that he was wrongfully convicted. His best shot at doing that was DNA. But to go up against the justice system in Missouri, he was going to need some serious help.
I said, Jim, I need some help. I got some action. The DNA we found, the sperm that they found, the judge's gonna give me a hearing.
That's next on Burden of Proof, one man's fight to show he's innocent. You can listen to new episodes every Thursday wherever you get your podcasts or on firstalerts4.com. This podcast is produced and voiced by me, Matt Woods. If you want to get in touch, send me an email, matthew.woods@kmov.com with 2 T's on the first name. This is a First Alert 4 original podcast.